Myself, Dr.M.Saranya, Assistant Professor of BBA Department. Now I am going to present a topic on transfer of titles and record. The title of a property is an ownership certificate. When we transfer the property from the original owner to someone else, there is a change of ownership. The property gets a new owner, and hence the title needs to be changed, and the new owner names get substituted for the ex-owner. The transfer of property involves the transfer of a bundle of rights. The new owner gets the rights to sell, mortgage, lien, and gift the property. Therefore, there are specific rules to be followed for the transfer of property title in the law. Adherence to these rules is must to ensure that the transfer is valid and legal. In India, the procedure for the legal transfer of property title is not easy. It is time consuming, requires proper documentation and payments appropriate fees or charges to the concerned authorities. It is advisable to hire property lawyers in India or take top law firms services to complete the transfer of property title as per law to avoid legal barriers later. The transfer of property is complete if the legal procedure has been followed. The procedure of transfer of property takes place in several ways. How a person acquires the title becomes vital to decide the right way to transfer the property of title. A person can obtain the property in many ways like inheritance, will, gift, sale deed, any other kind of transfer. Inheritance means transferring property to the deceased legal heirs by will or by applying law of succession. If the property is ancestral, the property develops upon the legal heirs as per the succession law. Similarly, if the property is self-acquired and there is no will made for it, the succession law applies. In such cases, the heirs apply to the concerned department or authority to transfer the property title to their names. They submit the application in the requisite format. A copy of the previous owner's death certificate and title deed. In cases there are multiple heirs, they can mutually agree to surrender their share in favor of one heir, and they can represent the authorities accordingly. Next one is will. When the deceased has left a will for the property's devolution, the beneficiary submit a copy of the will and death certificate to the concerned authority. If the will is in the name of a single legal heir, other heirs can file an objection and challenges the will. The property develops as per the court's decision. Next one, sales deed or gift deed. If the property is acquired through a sale deed or a gift deed, the title's legal transfer takes place once the deed is registered as per law. Thus, the parties approach the registrar to get the transaction registered and complete all the formalities of the process for the property title's legal transfer. In general, the document required are death certificate if the property is acquired after death of the owner. Next one is birth certificate of the applicants to know the relationship with ex-owner in some instance. Next one is succession certificate. Next one is the property tax paid receipt. Next one is the title deed of the ex-owner. Next one is sales deed, gift deed, or any transfer deed showing that the property has been transferred. Next one is share certificate of the society in case the property is a flat in a society. Next one is no objection certificate or real insequent deed as the case may be. Next one is application form in the requisite format. Next one is receipt of a fees paid. The process involves filling an application and proper documents and requires requisite fees to the concerned department authority. Whenever there is a legal transfer of the title of the property, the fact of change on ownership might be recorded in the public record. Thank you.